You've got Mr. Vogler, who's here for the people? Mr. McLennan. All right, this case, I did receive an update from the Department of Corrections that Altina decided not to charge the assault and battery. Is that correct, Mr. McLennan?
That's my understanding, Your Honor.
Okay, so Mr. Vogler, the Department of Corrections recommendation is that if Ms. Samp admitted the count 1 and count 2 technical violations, that the remaining violations would be dismissed and we'd continue her on probation. And recommended, looks like jail 3 days, credit 1, but that is that right? Okay. So that was their recommendation for 2 technical violations for the driving. So I just wanted you to be up to speed on that. And Mr. Vogler, do you know how Ms. St. wishes to proceed?
Yeah, so we're going to go ahead and admit to those technical violations.
Okay. Ms. St., would you please stand and raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And, are you Catherine Louise Samp?
I am.
Ms. Samp, you understand you've got the right to have a hearing on whether you violated probation, where the prosecution would have to prove that by a preponderance of the evidence. Do you understand that?
Yes, Your Honor.
You'd have the right to an attorney and to present evidence in your own defense. You understand that?
Yes.
You're on probation to me for operating while intoxicated, third offense. With these 2 technical violations being on separate days, the maximum penalty that you would face for those violations would be 30 days in jail. Do you understand that?
Yes, Your Honor.
Also, those count as 2 technical violations. If you reach 4 technical violations, the court could revoke your probation. Okay, so you're kind of halfway out of strings.
Yes, Your
Honor. Has anybody promised you anything other than what I outlined here in exchange for your plea?
No, Your Honor.
Has anybody threatened you?
No.
Is it your own free choice?
Yes.
Knowing all this, how do you wish to plead to counts 1 and 2 of violating probation?
Guilty, Your Honor.
So are you on probation to me for OWI third?
Yes,
As a condition, are you not to drive a motor vehicle without a valid license?
that is correct.
In violation of that, did you drive on or about March 19th?
Yes, I did.
And did you drive on or about April 6th?
Yes, I did.
As I understand, you weren't drinking on those occasions, is that
No,
right?
Your Honor.
Okay, why were you driving?
The first one, Your Honor, was to maintain my employment. I was working at Subway in Alpena. It's 15 miles out of town. Up until that point, I had a boyfriend, but he relapsed. So I was making my way to work. The second one was actually to go get fingerprinted for the first violation. I couldn't find a ride to the jail.
All right, thank you. Mr. Vogler, are you satisfied with that factual basis?
Yes.
Mr. McLennan?
Yes.
Mr. Vogler, are you aware of any other promises, threats, or inducements?
No.
Mr. McLennan?
No.
All right, Mr. Vogler, anything you want to say in your client's behalf?
Your Honor, I would, she was already sentenced to the 3 days in jail, credit for 1 served in Alpena. And, Alpena basically, my understanding was they held that sentence at least the time when she would start serving it until this court. And they had no objection to her serving any sentence here in Prescott County.
Does she have a preference for where she would do that?
Here, please.
All right, Ms. Samp, you don't have to make any further statement, but you're allowed to. Is there anything you want to tell me or more, or no?
I did just write something short that I'd like to read you, if that's okay. And then I can I give these to you, Your Honor?
What are those?
So I had 3 character reference letters from my therapist, my sponsor, and a friend I know in recovery. My community service hours that I got done, the electric bike that I just purchased so that I won't drive anymore.
Sure.
And then Catholic Human Services.
Sure. Actually, yeah. I'll receive those and then we'll give them to the probation agent, the probation file. Okay.
This is often the most important moment in a probation hearing. The defendant isn't arguing about guilt anymore. She's trying to convince the judge that she's changed sobriety, counseling, steady employment, community service, and rebuilding relationships with her children all become evidence of rehabilitation, and court actions always speak louder than promises, and now the judge has to decide whether this transformation is genuine.
And then I just wanted to say, I'm here to take full responsibility for my actions and move forward to close this chapter of my life. Before passing your sentence, I respectfully ask the court to consider the significant positive changes I've made in my life over the past year. I've achieved a full year of sobriety, gained a sponsor, and I attend nightly AA meetings. Going to rehab last year truly saved my life. Once I got into rehab, I realized that my substance abuse was stemming from unchecked mental health issues. I am wearing a scram monitor right now that I've had on since the 22nd of last month that will show my ongoing sobriety. I'm actively participating in personal counseling, and I've been prescribed medication to help with my long-term success. I'm currently working full-time to financially support me and my family, and my employer is a huge support of my recovery. To remain fully self-reliant and handle my daily commute independently, I recently purchased an e-bike. I want to emphasize that for the offense, I only drove out of absolute desperation to get to work and to get fingerprinted. My main priority right now is being a present, responsible mother to my 12-year-old son and my 6-year-old daughter. I've successfully regained visitation on weekends and working very hard for 50-50 custody with my children. I've successfully finished 500 hours of community service, and I provided the court with the character reference letters that speak directly to my growth, dedication, and hard work. I'm fully prepared to complete my sentence today so that I can put this behind me and keep moving forward with my recovery, Your Honor.
Great, thank you. Mr. McClung, any recommendations?
Your Honor, all things considered, it does sound like Ms. Samp has made some progress here on probation, and I'm hopeful that we see more of it. I think the recommendation for 3 days jail with 1 day credit is appropriate, and that would be my recommendation.
Okay, thank you. So, Mr. Fogler, if I did not impose that sentence, she would serve it, but it would be on the Alpena sentence.
Correct.
And then she'd have to serve it over there.
Correct.
She has a preference to serve it here anyway, if she's going to serve it.
Plus, she's arranged for time off at work in
Gotcha.
anticipation.
Anticipation. Okay. Okay. All right, Ms. Samp, when we arraigned you on this, I released you on a bond, which I'm sure Mr. Buckler can tell you is not commonly the majority of the time when people are on felony probation, it's alleged that they've committed a new offense, whether it's a felony or misdemeanor. I hold them without bond if they're committing any kind of crimes while they're on probation to me. And your drunk driving, I found to be particularly serious. There's a lot going on with you, a lot of moving parts. And I remember, I think we were trying to get you into treatment court, but then that treatment court kind of closed down right at the same time. So I still gave you a chance rather than just, switch to pure incarceration. But you need to know that, if you were to violate, by drinking or drinking and driving, there'd be significant incarceration you'd be looking at. It'd probably be prison, jail. But boy, I was impressed at the arraignment not impressed that you drove. And even if you had, in your mind, you think you had good reasons, I want to encourage you to think that's maybe addiction thinking and not recovery thinking. Okay. That even when you think you don't have a good choice, you do have a choice. And you can reach out and call everybody on your list, every sponsor you got, your boss, you make better choices in those situations. But thinking I have a good reason or an excuse to break the law, that's the addiction talking in your head. But I was impressed at the arraignment, at the progress that you've made. I'm pleased at the progress that you've made. And that makes me hopeful that you're going to do well on probation. So I do find that a probation violation has been established on the defendant's plea. This is the first and second technical violation. I'll dismiss the remaining violations. I'll continue you on probation. The progress you've made.
This sentence sends a powerful message. The judge could have imposed a much harsher consequence, but instead he recognizes the progress she's made while still holding her accountable. Notice the balance. Mercy doesn't erase responsibility, and accountability doesn't eliminate hope. That's exactly how many successful probation cases are handled when genuine rehabilitation is backed by real evidence.
The steps you've taken with the e-bike, the attitude that you have here today, I would not be giving you jail. But you're already doing it anyway, and you've made some preparations and would prefer to do it here. So we'll impose 3 days jail credit for 1 day served. When you're out, contact your agent and continue on the path that you have been. But even the little choices help to build the life that you want. So, make a series of small, good decisions, and those will pay off in the long run. Someday they'll pay off to you getting your license back. But if you drive without it, you'll never get it back. All right, good luck to you, Miss.
Thank you so much.
And we did initially talk to the probation agent that when we were here last time, the court amended her conditions of probation to wear the scram unit.
Oh, yeah, I think we can take that off now when she's released from the job, you think?
She has had no violation. She's done very well on that, and I would not be opposed to revoking.
Okay, yeah, so we can remove the screen.
Thank you very much, Ron.
And can you do this, Mr. Jerusalem? Can you name this to Agent Gillespie for the probation file? All right, Mr. Vogler, are you representing Mr. Green on the probation file? Counsel, you want to state your appearances, please?
Zachary McLennan for the people.
Mike Vogler, I represent Haley.
Okay, and looks like the 93399 file I referenced is being dismissed, as well as a district court matter. And we have sentencing in 93400 on a charge of absconding, a 4-year maximum. Guidelines are scored at 5 to 23 months. We have a sentence agreement for a county cap. I have reviewed a letter from a minister regarding Miss Haley's participation in programming while she's been in the jail. Mr. Vogler, if you had a chance to review the report and recommendations with your client.
Yes,
Do you have any additions or corrections?
there are none.
Any scoring challenges? Mr. McLennan, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
Mr. Vogler, anything you want to say to your client?
I do, I certainly appreciate Mr. DuVernay's letter to the court. I agree with a lot of what he's saying there in terms of my own personal impressions of my client, having represented her many years in the past and more than one occasion. There certainly is a change here. It certainly seems like that she's vested now more than I've ever seen her in her future. She's never missed, my understanding, an AA class. She goes to that all the time. She's also participated with Mr. Pierce in that program, never missed. She's also now engaged in some Bible studies, which just have started to happen. Given the GED situation, she has decided to revisit all that, and so she started that program now in the jail. Her plans are when upon release are she will have a vehicle. She'll return to her mother's house. She'll have employment there, taking care of her mother. She's going to continue in counseling and maintain her sobriety. And I would ask in this case, Your Honor, that the court go to the lowest end of the guideline, which would be 5 months. I think she's been preparing herself well since she's been back in jail.
Hey, thank you. Miss Frank, you don't have to say anything today, but you're welcome to. Is there anything you want to say or no?
I just want to say that I really have been trying to invest in myself and trying to break the cycle so that you don't ever see me again and make a complete 180 in my life. And I apologize to the court.
Mr. McLennan, any recommendations from the people?
Yes,
Here's the key takeaway from this entire hearing. The judge isn't claiming the defendant is beyond redemption, but he's making it clear that trust has to be earned over time. Even after acknowledging signs of improvement, he still imposes a meaningful jail sentence because accountability remains the foundation of the justice system. Real change begins after the courtroom, not inside it.
Your Honor. Miss Frank is 34 years old, has 2 felonies, 11 misdemeanors. Unable to verify her education level, it looks like from PSI, but potentially a GED. I think when I look at this file, Your Honor, I'm looking back to 2009 to today. And there's a fairly extensive history of involvement with the court system. And during that involvement, there's been multiple failure to appears, multiple unsuccessful probations. And we see more of the same as we're here today. She was on bond for 2 misdemeanors and a felony when she decided to abscond and try to skip court. She had a good plea offer, and that allowed her to get out of jail for a while, and she took advantage of that and thumbed her nose at the criminal justice system. Your Honor, I don't think she would be a good candidate for probation. I think the plea agreement with the county cap is a great benefit to her, and I think that the full county cap would be appropriate. Thank you, Your Honor.
Thank you. Well, Ms. Frank, and obviously all the stuff the prosecutor said is pretty well documented, you know, it's, you can acknowledge that you've got a past of involvement in the court system and in not really complying when you're on probation, and also sometimes frankly lying to us when you're on probation, committing more crimes. Most of those are theft crimes, and you know, they may be related to some of your substance abuse issues and other struggles. We had you in the Swift and Sure program, and you got removed. You got 6 months in jail in the past. And in this case, you had another crime of charge for stealing some prescription medications. That charge being dismissed, but you absconded while that was pending. So you're here for the absconding. That's pretty good plea outcome for you, where that goes away because the absconding could have been consecutive. And also with this guidelines range, you know, you're now entering with your criminal history and your poor history on supervision. Now, when you come to court, the discussion is, do we give Ms. Frank county jail or do we send her to the state prison? So that's the conversation that we're going to have every time you come to court now. So we've got Mr. Vogler did a great job for you, getting rid of the consecutive pace and getting county cap. So we take prison just completely off the table. So that's, I'm not going to send them to prison. So the question is, well, how much jail? And, you know, the prosecutor wants the full county cap that they negotiated. Mr. Vogler wants me to go on the low end, the 5 months. There's some pretty good arguments both ways for that, to be honest. You know, the letter from Mr. DeVerney shows that maybe you're starting to wake up to what's going on in your life. I don't know. As he put in the letter, only time will tell, right? Your choices that you make are going to tell everybody that. The recommendation from the Department of Corrections probation agent is, I think, very measured. It recognizes that you're not a good candidate for probation, recognizes the straddle cell, possible prison, and the 12-month county cap, and recommends less than that county cap amount. I think that's a very reasonable and measured recommendation, and I'm going to.
Now we're looking at a completely different situation. Unlike the previous defendant, this case comes with years of criminal history, repeated probation failures, and an absconding charge. Prosecutors always emphasize patterns over promises because judges often view repeat behavior as the strongest predictor of future conduct. Can a heartfelt apology outweigh years of documented violations?
Adopt that recommendation. I find it to be proportionate to the circumstances of this offense and the offender. So I'm going to order that you pay $130 in the crime victims assessment. It'd be $350 in court costs and $68 in state costs. And I'm going to order that you serve 9 months in the Presque County Jail. You'd be credit for 115 days that you've already served, and will indicate on the judgment of sentence that you can participate in the GED program and or the jail trustee program if the jail determines you eligible, and receive credits on your sentence for participation in those programs. You can file an appeal if you wish by filing an application to the Court of Appeals. So we're going to hand you a piece of paper explaining those appeal rights. Appeal rights. We'll ask you to initial one copy for us, so we have a record we gave it to you. The other ones be to fill out if you want to take an appeal. But once you're released from the jail, you're not on probation with us, right? You just have to set up a payment plan with the clerk's office to get those fines and costs taken. Okay?
Thank you, Your Honor.
All right, good luck to you.